I am delighted to welcome someone who really needs very little introduction. Someone who is a barrister by trade, who has protected and talked about human rights for many, many years, and it is my great pleasure this evening to welcome the Director of Liberty to talk on international human rights and national human rights, Shami Chakrabarti.
Well, thank you very much for that lovely, kind but also brief introduction. It's great to be back in Leeds, and I love the way that this talk has been framed, not by me, but I think with great foresight, because one of the most important human rights messages in modern Britain and indeed in the 21st century world has to be that this planet is shrinking and interconnected, and surely whether it's questions of the new frontier of civil liberties debate that is the internet, or whether it's questions of the relationship between foreign policy and home affairs policy, between military interventions and refugee crises, surely over there and over here cannot be separated in the way that some parts of our polity and our press attempt to do. As I say, it's wonderful to be back in Leeds, but be afraid, be very afraid. The Sun newspaper once called me the most dangerous woman in Britain. It has been the most enormous honour and privilege to be described that way by that particular institution. And it's really interesting because you can imagine that I've been dining out on that for some years, because who wouldn't milk that, right? Who wouldn't milk that? And you get very different responses in different parts of the country and with different audiences. And the closer you get to the great city of Liverpool, the better the chance you have of getting a standing ovation before you So imagine my absolute disgust when the Daily Mail newspaper decided to spoil my fun about this time last year and decided that title no longer belonged to me, and they gave it instead to an upstart charismatic politician north of the border. And to add insult to injury, my friends, the First Minister of Scotland is a little bit younger than me as well. So it's probably hardly surprising that it's time to hang up the megaphone, or at least to stop being caretaker of liberty after 12 years in what's been a wonderful but sometimes daunting role. While we're on the subject of Scotland and I suppose Europe and Britain, I think we're at a very, very curious, frightening, challenging moment in British politics. And the older I get, the more I think that life begins to resemble a Renaissance painting, but with layer upon layer of irony where the paint should be. Because, of course, in the First Minister of Scotland, we have someone who is a Scottish nationalist, but who nonetheless will defend the international human rights framework and indeed internationalism. And we have a Prime Minister in Westminster who leads something called the Conservative and Unionist Party, who has promised to scrap our Human Rights Act and at times has even threatened to pull out of the European Convention on Human Rights. It's a very, very curious moment in British politics and human rights discourse. And of course, many of you will know, because you are lawyers and scholars, that the human rights settlement is now interwoven with our rather delicate devolution arrangements in this country. So the Human Rights Act is interconnected with the Scotland Act, and the European Convention on Human Rights is interwoven with the Good Friday Agreement in Northern Ireland, which is not just an internal Northern Ireland matter, it is actually an international treaty with the Republic of Ireland as well. So it's all very well to talk tough when it comes to the Convention and the Human Rights Act, and to use it for populist sabre rattling, and to deliberately, in my view, and very mischievously conflate the debate about international human rights standards and continuing membership of the Council of Europe and the preservation of the human rights Act, deliberately conflate that debate with the Brexit debate that we're all having at the moment. And that is the game. That's not a theory. That's my firm view, and I have it on good authority. There are some people in the government, in the Remain campaign, who have deliberately whipped up hatred for the ECHR and the HRA in order to give some red meat to their xenophobic right wing. And equally, to be fair, there are some people in the Leave camp who are actually supporters of the ECHR and the HRA. So again, curiouser and curiouser, said Alice. But first, perhaps, in case you don't know, a little about Liberty. The National Council for Civil Liberties was founded in 1934, which is clearly a very different moment from this one. In 1934, there was barely TV, let alone reality TV and CCTV everywhere. In 1934, DNA had yet to be discovered, and that means no possibilities to use it to great probative effect in the criminal justice system, but equally the capacity to build what became the greatest DNA database per capita in the world. And surprise, surprise, when you go in for the blanket and arbitrary collection of intimate data, when you go in for arbitrary power, it becomes actually very discriminatory in practice. And that database, as we know, was impugned in the Court of Human Rights under Articles 8 and 14, not least because there was such a predominance of young black men who'd been arrested and possibly never even charged, let alone convicted, on that database. And in 1934, and this is what younger audiences, school audiences in particular, find absolutely impossible to believe, there was no internet. It's like, Mum, the Wi-Fi's down again, but permanently. And again, that means, none of the great things that the online world brings, like democratization, communication, such an opportunity to level the playing field between the powerful and the powerless, so that people can collaborate and campaign unmediated by the media and by governments and so on. So a wonderful thing, but also it has, of course, its dark side, whether that is as an agent for conveying conspiracy and hatred and pornography and terrorism, but also as a means by which the powerful can intrude upon the vulnerable. And, one of the hot debates and ongoing issues alongside the debate about scrapping the Human Rights Act is the matter of the so-called Investigatory Powers Bill. That's what the government calls it. It gives it a nice, dry title, and then activists call it the Snoopers Charter. And this, of course, has come about as a direct result of Edward Snowden's revelations. Now, some of you may think that he is a traitor, others that he is a public interest whistleblowing hero. All I would say is, wherever you think the balance should be struck in this balance between personal privacy, not just as an individual human right, but as a societal value, personal privacy on the one hand, and lawful, proportionate surveillance for good reasons on the other hand. Is it right that security agencies and governments on both sides of the Atlantic went in for wholesale, blanket surveillance, not just in relation to particular suspects, suspect individuals or suspect groups or suspect sites, but in relation to entire populations without public knowledge or debate, let alone consent, let alone parliamentary engagement or legislation, or indeed the intervention of the law? And I think not. And so my own view, surprise, surprise, is that he is a whistleblowing hero, and it is quite right that now there has to be a debate about the appropriate balance between those two interests. And I suppose if Mrs. May were here or someone with the counter view were here, they would say, well, the innocent have nothing to fear from online surveillance. Nothing to hide, nothing to fear. You've presumably heard that slogan over the last decade and pretty much since 9/11, I would say, right? Nothing to hide, nothing to fear. Well, I would remind people who take that view of what happened in 1934 that led to the formation of Liberty, the National Council for Civil Liberties. Hunger marchers had come from this part of the country, from the north of the country, and they had marched all the way to London's Hyde Park. Because, some things change, but some things don't change nearly enough. And 1934, however different, was a time of great economic austerity, uncertainty, inequality. And people were desperate for shelter and food and opportunities for their families. And they marched all the way to London's Hyde Park, where they were promptly duffed up by the Metropolitan Police. Forgive the legalistic language there, but that's what happened. And now, of course, that would never happen today, would it? And what's more, the particular method that was used was that undercover police officers dressed as hunger marchers. And they behaved violently, deliberately, to trigger and justify a violent policing response. They were agents provocateurs. And that would never happen today, would it? And when people go, no, Shami, that wouldn't happen today, and some people do, I remind them of my friend, the great Doreen Lawrence. Now, I don't think it's an exaggeration to suggest that Doreen, who's now a national treasure, so much so, not just because she's in the House of Lords, quite rightly, but she's even in Marks and Spencer's commercials now, right? I mean, that's national treasure status. Paid for her kitchen extension, she told me. But I don't think it's an exaggeration to compare Doreen to a Nelson Mandela or a Martin Luther King in terms of what she's achieved for race equality in this country. There would have been no Race Relations Amendment Act and no Equality Act, and there would not be a duty on public authorities like the police to employ race equality. So for all the years since the Race Relations Act, the duty was only in the private sector, not in the public sector. Imagine that. Imagine that now, in 2016, the public sector allowed to discriminate. And you'll recall Doreen's story. She didn't train as a lawyer like me. She didn't choose the path of activism. It chose her in the most horrific circumstances. And those of you who are parents, I think might agree with me that there are few things harder to contemplate than the untimely death of your child. It's not in the natural order of things, let alone to lose your child in a racist murder, and then to find that the police are not interested because your son is a teenage black boy and not a teenage white boy. And Doreen's activism, not just on behalf of her own family, but on behalf of everyone's families, because that's what equality is about. Doreen's activism, as you know, ultimately led to the Macpherson inquiry and then to the Race Relations Amendment Act and now incorporated into the Equality Act. But years later, even after those achievements, the hits keep on coming. And Doreen, just a few years ago, found out, as a result of investigative journalism, that not only were the police not adequately investigating Stephen's murder, when she began to be an irritation and to make headway in her campaign against the police, they put her under surveillance instead. And guess what? They put undercover officers in her friendship circle, in her campaign, in her home. Nothing to hide, nothing to fear. The innocent have nothing to fear from unchecked surveillance powers and unchecked police powers. I don't think so. And if that's not enough, remember the Greenpeace women. Do you know where I'm going with this? Right, these are not jihadis, these are radical vegetarians. Right? The worst they're going to be caught with is some questionable quinoa or something like that. That's how you pronounce it. Somebody told me, is that right? It's quinoa. Anyway, so these are, these are Greens. And these women, they go to Greenpeace meetings and they get involved as activists and they form friendships and intimate relationships and they think partnerships with men with whom they think they share values. And they start sharing their most intimate lives In some cases, they have children together. They have children together. And these men, I've seen the photographs, these men feature in the family photographs, in the frames around the house, all the family events they've been to together with their wider families. And sometimes after up to 7 years, when this relationship dissolves and he's off, well, that's life, you know, but he's off. Many years later, they find out that this man was actually an undercover officer from the Special Demonstration Squad of the Metropolitan Police. Nothing to hide, nothing to fear. The innocent have nothing to fear from unchecked police power, unchecked surveillance power. Really? Now, to be fair, I do want to provide a little balance. If Mrs. May were here, she would say, well, that's all very well, Shami, but bad stuff happens online, and it cannot be a completely ungoverned space. We do believe, do we not, in the rule of law. Here we are, Leeds Beckett Law School, we believe in the rule of law. So we can't say that it's a no-go zone online. Bad stuff happens there. I agree. And bad stuff happens offline in the real world too. It's not a comfortable thing to talk about, but we know that bad things happen in domestic dwellings, do we not? These great old dwellings that have been used as family homes for a number of years, I would venture to guess that any property that's been a family home for longer than, how long? I don't know, 10 years, 20 years, 30 years, that home has at some stage or other been a crime scene. Now maybe we're talking about a bit of petty crime, right? Maybe we're talking about a bit of, I don't know what, mortgage fraud, benefit fraud, tax fraud. Maybe we're talking about a little bit of common assault, more serious violence, domestic violence, sex crime. But we do know, do we not? Yesterday was International Women's Day. We do know that very bad things can happen behind closed doors in the family home. Agreed? And so, we now, of course, have technology, digital technology, we have modern technology that would allow us, would it not, to say we're going to change the legal and physical architecture of our country, of the world, so that microphones and cameras will be planted in everyone's home. In the living room, in the bedroom. But don't worry, we're not actually going to monitor every second of your life. We're just going to record it. We're not going to look at it. You're not so interesting, you know, we're not going to look at it, don't worry. It's just going to be recorded and stored. And then we might look at it sometime later if somebody accuses you of a crime. Or perhaps we might look at it on a random basis. Or perhaps we'll search for keywords. Or perhaps we'll develop some other algorithms that will help us determine when and where we should look. It could be really valuable material, couldn't it? Are we happy with that? Well, all I would say is, some people, when I talk to them, say, yeah, I'm happy with that. All I would suggest is that if you're not happy with that, you should not be happy with what is being proposed and perpetrated by governments in the online space. What we are talking about with this investigatory powers bill is the ability to record and potentially access every second of your online life. Your web browsing, your contacts, think about your smartphone or your other device or your tablet. Think about what's on there. I mean, mine would include which trains I've taken, my banking, and things keep popping up that I don't ask for, by the way. Like there's this health app that tells me how many steps I took yesterday. I didn't ask for that. Anyway, that's there. My contacts, who I've spoken to, who I've texted and emailed, for how long. My location data. This is cool technology, isn't it? Because it will tell you where the nearest pizza is. It will tell you where your pizza is in development. Is that for real? Your pizza is in development, right? It's cool technology, but it will also tell people where you are and, by comparison, who you're with. We haven't asked you to turn your mobile phones off, but you might want to think about your location data, because you're currently with the second most dangerous woman. What you've been reading, what you've been thinking about, your politics, your concerns about your health, your mental health, your sexuality, your goodness knows what. And I think for a lot of younger people, they're often living more intimately online than they are in the real world. Go to a teenage bedroom these days and, the usual kind of pile of clothes and whatever, but the key to the intimate world is the device. And that should all be scooped up, that should all be recorded beyond necessity for billing purposes, that should all be recorded and held on to, and then accessed potentially on a bulk basis, without judicial warrantry, without a particular person being suspected of a serious crime. That is what has happened outside the law, outside politics, and that is now what is to be made formal, what is to be made law if the Investigatory Powers Bill passes without much amendment. Nothing to hide, nothing to fear. But anyway, back in 1934, after the scandal of the oppression of the hunger marchers, a small group of people, far smaller than this generous audience today, decided that something must be done. Small group of ne'er-do-wells who never did anything else important with their lives. People like, Clement Attlee and H.G. Wells and E.M. Forster and Vera Brittain and Edith Summerskill, and the list goes on. They met in the crypt of St Martin in the Fields Church in Trafalgar Square. The old church opposite the National Gallery. Now, of course, today they would have, tweeted or blogged or Instagrammed or Snapchatted or something that I don't really understand to announce their campaign. They couldn't do that because it was 1934. And so they wrote a letter to what was then called the Manchester Guardian newspaper. And they decided that they would form the National Council for Civil Liberties to keep watch of the entire spirit of liberty in our country. What audacity, what amazing, optimistic audacity. They didn't have a royal charter, they didn't have any official sanction from any institution of the state whatsoever, but they became the National Council for Civil Liberties, which ultimately, at its heart, remains a group of concerned people who say something must be done, a membership organisation, which then operates through its staff to protect human rights, whether it's in the courtroom or the Parliament chamber or the newsroom or the classroom or all these places where human rights have to be kept alive, in my view. And that's liberty even today. The next important moment in my story comes after World War II. And as you know, that is the moment, a unique and yet to be repeated moment, when after the horrors of the Holocaust and the Blitz, people slightly to the left of politics, slightly to the right of democratic politics, people who represent all the great world religions come together and decide that if we as a species are not perennially to descend into barbarism and war, we've got to agree on some basic, universal, non-negotiable values around which to negotiate. Have to be some universal values. And that's Eleanor Roosevelt's legacy, but as I say, it's also people from all over the world. It's sometimes suggested that there's some sort of Western imperialist construct, but not a bit of it, not a bit of it. The philosophers and the lawyers and the politicians that got involved in the debating and the discussion and the negotiation, as is revealed in the historic documents, really came from all over the globe. And they attempted to look at everything that was best about human thinking and aspiration. So that's the Universal Declaration, and in turn, that was to be made enforceable by a series of regional instruments, including our own European Convention on Human Rights. Article 2, the right to life. Not everlasting life, you understand. You need medical and clerical miracles for that. Lawyers can't deliver it. But nonetheless, a right to protection by the state for your life, and a right to an independent investigation into untimely death. And my colleague Emma Norton, our star litigator at Liberty, is currently slaving away at Woking Coroner's Court that great palace of justice, working on the Deep Cut inquest, and you may have read a little about this in the press. Over 20 years ago, these young squaddies die in mysterious, to say the least, circumstances, and no proper independent investigation until now, because Article 2 required it, and we were able to use that to get the inquest that the MOD didn't want, that Surrey Police didn't want, etc., etc. And by the way, one of the reasons that is given for scrapping the Human Rights Act and replacing it with a so-called British Bill of Rights with common sense, there's an interesting jurisprudential idea. One of the reasons that's given is that the MOD in any new Bill of Rights should be untouched. They should be outside human rights law. We'll tell that to the Deep Cut families. Tell that to the family of Anne-Marie Element, who served in Germany in the Royal Military Police. She came from a military family. She always wanted to serve her country in that way, and she complained that she was raped by her comrades. And guess what? When you complain about rape within the Royal Military Police, who investigates? Yeah. And let's just say it was a short and rather cursory investigation. No further action, except that Anne-Marie gets bullied because she's the girl that cried rape, and she has broken ranks with her comrades. And after a period of time, she takes her own life. But in addition to Article 2, we have Article 3, the right not to be subject to inhuman and degrading treatment and torture. Now, of course, in these war on terror years, we often think about Article 3 in the context of Guantanamo and extraordinary rendition and all of those scandals. But we forget that Article 3 has been really important closer to home, and in particular for victims, and in particular for victims of sex crimes. Before Article 3 was employed against the UK in the Strasbourg court, it was not uncommon for women to face cross-examination in person by the man they accused of rape for up to 3 days at the Old Bailey. Because under the common law, there was what seemed like an absolute right to choose your representation, including to represent yourself. And the trick was to have your counsel and have your solicitor right up to the day of trial, right up to the court door, and then sack them. And then cross-examine your accuser in person for up to 3 days. And think about that. Think about how hard it is to be a rape complainant anyway, and the attrition rates. So until the employment of Article 3 and cases brought by women in that position, that was how the law was, and then it was changed. Article 4, the right against arbitrary detention. The right against slavery. That seems like a distant right. Didn't we abolish the slave trade hundreds of years ago? But there wasn't a criminal offence of holding someone in slavery or servitude until 2010. Now, the police would traditionally say we don't need one because if you lock someone in, that's false imprisonment. If you threaten them with violence, that's a crime. If you perpetrate violence, that's another crime. But it's not always that simple for vulnerable people who've been trafficked or who have learning difficulties or who are illegal migrants who are otherwise vulnerable in the context of domestic servitude or the agricultural context and sex work and so on. And Liberty, working with grassroots organisations, found that there was a real gap here and lots of very vulnerable people were not being protected by the police. And again, we had to threaten the UK government back in 2010 with Strasbourg litigation, and we were able to table an amendment to a criminal justice bill. They're like buses, there's always another one coming round, you know. And we tabled an amendment thanks to Baroness Lola Young, a crossbench peer. It was drafted by Lord MacDonald, the former DPP, and there is now, for the first time since 2010, a law, a criminal offence of holding someone as a slave. Article 5, as you know, the right against arbitrary detention, and it's been very important in all sorts of settings, but there's a lot of work yet to do. I think in particular in the context of refugees and asylum seekers who are still subject to indefinite detention without time limits or proper process, and these days without proper access to legal advice and representation either. Article 6, the right to a fair trial. Wonderful. You know, they called it the English right when they were drafting the European Convention, and surely we had such a strong tradition of that. People talk a lot of rubbish about Magna Carta. Last year I had Magna Carta about up to here. Didn't you? Like these people that want to scrap the ECHR and pull out of the HRA saying it doesn't matter because of Magna Carta. In the words of that great legal philosopher Tony Hancock, remember Magna Carta, did she die in vain? And of course there's lots that isn't there. Not much joy for Jews and women being discriminated against, nothing about torture and free speech and privacy, and because it's 1215, you know. That's 1215 AD, not 1215 this morning. But the beginnings of due process rights, including presumptive innocence in criminal trials, and equality of arms and so on. But can it be real if people don't have legal aid? That's I think, the real question about Article 6 in modern Britain. Privacy, we've discussed, a very hot topic. Article 9, freedom of thought, conscience and religion. The right to the faith of your choice, to no faith, and I think perhaps most importantly of all, the right to be a heretic in any faith community. You know, the gay Muslim, the woman that wants to be a bishop, the Sikh woman who wrote that play that was shut down by a baying mob at the Birmingham Rep all those years ago because the play defamed her religion or whatever it is. And more recently, the government of India banning that wonderful documentary, India's Daughter. What an absolute scandal. It's supposed to be one of the most numerous democracies on earth. Our Prime Minister rolls out the red carpet for his Indian counterpart, and yet they've banned India's Daughter, that documentary about the Delhi rape. Article 10, of course, free expression. And like most of the rights and freedoms we're talking about, this isn't absolute. It's incredibly important. It's the lifeblood of democracy, but it isn't absolute. But goodness me, we should be slow to interfere with it, surely. Very slow to interfere with it. And I do think it's a live issue on campuses and in educational settings today. On the one hand, because of the government's prevent agenda and government's attempts to now not just to intrude on what might be a conventional criminal offence like inciting murder, but government is going to decide what is extremist and what is radical. When I was at college, radical was a good thing, you know. But anyway, I suspect that even though the Prime Minister is about my age, he would have a different view of whether radical could ever be a good thing. But fluffy concepts like domestic extremism and radicalisation, and more fundamentally, is it right that the sacred space of the academy should become a place of surveillance? Now, don't get me wrong, I'm not naive to threats, and I do believe in having security agencies and having police services and having surveillance within a legal framework. I just don't like this constitutional cross-dressing. Now, cross-dressing's fine, but constitutional cross-dressing is not fine. And people who come to school or to university or to any educational setting should not worry that they are living in danger of being reported by their teachers or their youth workers or their lecturers or their professors. And the whole concept is completely counterproductive in my view. And then, it's not always Big Brother. Sometimes we can be foolish little brothers and sisters to each other as well. There are students who are no platforming each other left, right and centre. I had an email last term, a very charming and polite email from a women's officer at a great university asking me not to come and speak at her university. The reason given was that not enough women were being invited to speak at her university. And so, look, you're the academics, explain it to me, right? I'm just a scruffy activist. You explain it to me. Not enough women were being invited to speak at her university, and so she decided to write to all the women who were due to speak that term, and we should boycott the university. And I it was a very charming and polite email, to be fair, and I wrote back, tried to be polite too, and suggested that she might reflect on her on her tactic from a feminist perspective, and wasn't this the equivalent of saying, quite rightly, that the lack of women's representation in Parliament is an absolute scandal, and therefore, in the run-up to the next election, we'll ask all sitting MPs to resign if they're women, and we'll ask all other women to boycott the election. And look, more fundamentally, whether things like no platform were once a valuable tactic or not, that was a tactic and not a principle. And sometimes progressives forget the difference. And my view is, in the internet age, there is no such thing as no platform anymore. Just narrow platforms and small platforms where people talk to people who agree with them online. And surely the academic space is the space for people to be challenged and to hear the counter view and to learn to disagree well. And if we are going to be a democratic antidote, and actually a radical antidote to the kind of hate that's being peddled by people like ISIS, haven't we got to show another way of being and another way of disagreeing and disagreeing well? And I don't believe that's possible if whole communities feel that places like this are no longer safe because of various duties to report to the state. That's my view. And then freedom of association, of course. And to my mind, the key to the human rights kingdom, Article 14. We lawyers call it equal treatment under the law or non-discrimination, but we humans might call it empathy. Like treating other people as you'd like to be treated yourself and walking around in other people's shoes. And I think that, again, you find traces of it in all the great learning from around the globe and all the great thinking and writing about civilization and how we should rub along together. And I think it becomes actually a really hard-edged protection in a human rights framework that involves so much compromise and so much balance and so much necessary and proportionate interference, because it's a way for the courtroom and the ballot box to work together. Because we know, don't we, the democratic majorities will so readily and easily trim on the human rights of disenfranchised minorities, whether they're children under 18 or whether they're asylum seekers, someone without the power, without the vote, without the power. And the beauty of Article 14 is it empowers lawyers and judges to say, okay, if you want everyone to carry an ID card, it will be everyone, not just the disenfranchised minority. And you have to practice the principle of non-discrimination. And when people think that this intrusion, this violation might apply to them and their family, people they identify with, and sometimes, often, they change their minds. That, to me, is the key to the human rights kingdom. Because in my experience of doing this job for 12 years, everybody loves human rights. Everybody. Mr. Gove, Mr. Cameron, the lot. Daily Mail, they all love human rights. Their own. Yeah? It's a bit like further education. For my children, not other people's children, right? That's like human rights. And even now, my speech is free and yours is a little more expensive, and we better do something about that shortly. But that, I think, is one of the crucial aspects of this debate that needs to be brought out. And ultimately, in the context of over here and over there, and human rights in Britain and human rights in the wider world, what kind of signal would it send to people in Putin's Russia and people in the Middle East? We celebrate the Arab Spring for as long as it likes, and our leaders want to pontificate about human rights abuses all over the world. But what signal would it send for Britain to walk away from the international human rights framework now? Whether by, scrapping the Human Rights Act and diluting it, or whether from actually pulling out of the Council of Europe, whatever happens in this Brexit debate. It seems to me that in 2016, everybody on earth pretty much has an existential choice to make. Do you want the very, very limited protection of being treated as a citizen, a passport holder, in one little corner of the globe? Do you want a citizen's privilege that can be given and taken away by the political community at any time? Or do you want the protection that comes with being a human being everywhere? A human being everywhere, or a foreigner in almost every part of the globe. That is the choice. And that's why I say that we have a fight, not just as lawyers, but as people in this country to save that framework. I suppose that Tom Bingham remains the greatest jurist of my lifetime. And he addressed Liberties Members' Conference 7 years ago. It was our 75th anniversary. And he set out all the different articles far better and more eloquently than I ever could. But he ended like this. He said, which of these rights would you wish to discard? Are any of them unnecessary, superfluous, un-British? There may be some people who would like to live in a country where these rights are not protected, but I am not of their number. Nor am I. Thanks for listening.